Picture an ordinary Tuesday. You have a valid concealed carry permit. You have done everything right, and you run 3 errands, a stop for gas, a quick trip into the grocery store, a drop-off at the dry cleaner. Under a law that was on the books in Hawaii until 3 weeks ago, that exact Tuesday could have made you a criminal at least 6 times over. Not because you did anything violent, not because you threatened anyone, but because you walked into ordinary businesses open to the public without first getting the owner's explicit permission to be armed. That law had a nickname among the lawyers who fought it. They called it the vampire rule, because like a vampire in old folklore, the right to carry legally could not cross the threshold of a business unless it was specifically invited in. On June 25, 2026, the Supreme Court killed that rule, and 8 days before that, in a separate case, it did something almost nobody predicted. It ruled 9-0, unanimously, on a different gun rights question entirely. 2 major Second Amendment rulings in the same 8-day window, one nearly unanimous, one bitterly divided, both touching millions of gun owners across multiple states at once. If you know someone who carries, or if you just want to understand what your rights actually look like right now today, stay with me because I am going to walk through both rulings using the actual opinions, not the recycled headlines already spreading half-right versions of both. Quick thing before we get into it. I track Supreme Court decisions and gun law changes the moment they are handed down, not weeks later once everyone else has already gotten it slightly wrong. If that is useful to you, subscribe and turn on the bell, because the state-level response to these 2 rulings is moving fast right now, and I do not want you finding out third hand. 2 seconds, and let's get into what the court actually said. To understand why these 2 cases even reached the Supreme Court, you need the 4 years of history sitting underneath them. In 2022, the court decided New York State Rifle and Pistol Association versus Bruin, ruling that the Second and 14th Amendments protect the right to carry a handgun outside the home for self-defense, and that any modern gun regulation has to be consistent with the nation's historical tradition of firearm regulation, not just a policy the government thinks is reasonable. That historical tradition test replaced a softer standard many lower courts had been using for years, one that let a regulation stand as long as the government had a reasonably good public safety justification for it. Under Bruin, a good justification is no longer enough on its own. The government has to point to an actual historical analog, a regulation from around the time the Second or 14th Amendment was adopted that is relevantly similar to the modern law being defended. States that had made it extremely difficult to get a carry permit in the first place, Hawaii among them, could no longer simply deny permits at their discretion. So several of those states pivoted to a different strategy. Instead of restricting who could get a permit, they restricted where a permit actually worked in practice. Hawaii's version, passed in 2023 as part of a law called Act 52, flipped the default rule for private property open to the public. Under ordinary common law, anyone has an implied license to walk into a business that is open to the public unless the owner says otherwise. Act 52 reversed that. It presumed every business off-limits to a licensed concealed carrier unless the owner affirmatively said carry was welcome through a posted sign, a verbal statement, or something in writing. Jason Wolford, a Hawaii concealed carry permit holder, along with several other Maui residents in the same position, backed by a group called the Hawaii Firearms Coalition, sued, arguing the list of off-limits places was so exhaustive that it effectively nullified their permits entirely, since almost everywhere a person actually goes during a normal day is technically private property open to the public. The case moved through the lower courts for 2 years before reaching the Supreme Court, and it is worth knowing that history because it shows this was not a rushed or one-sided process. A 3-judge panel on the Ninth Circuit ruled on Hawaii's law alongside a similar law in California in September of 2024, and interestingly, it split the 2. California's version, which only allowed consent through a physical posted sign, was struck down as too rigid by that same panel, on the reasoning that requiring a business to go out of its way to purchase and display a specific sign when the vast majority of business owners have no particular opinion either way about armed customers effectively defaulted most businesses into a ban by inertia rather than genuine choice. Hawaii's version, which allowed consent through a sign, spoken words, or writing, was upheld by that same panel as a comparatively more flexible approach. Wolford and the other plaintiffs asked for the full Ninth Circuit to rehear the case. That request was denied in January of 2025, and they petitioned the Supreme Court directly. The court agreed to hear the case on October 3, 2025, specifically limiting the question to how the Second Amendment applies to privately owned property that is open to the public without reopening the broader Bruin framework itself. Oral arguments were held on January 20th, 2026, and the decision came down 5 months later, on June 25th. Here is exactly what the court held. By a vote of 6-3, the justices ruled that Hawaii's default rule requiring express permission before carrying on private property open to the public violates the Second and 14th Amendments. Justice Samuel Alito wrote the majority opinion, joined by Chief Justice Roberts and Justices Thomas, Gorsuch, Kavanaugh, and Barrett, with Barrett also writing a separate concurrence that Thomas and Gorsuch partially joined. In his opinion, Alito described the practical effect of Hawaii's law as staggering, walking through how an ordinary day of errands, the exact scenario I opened with, could turn a licensed, law-abiding carrier into a repeat criminal without them ever intending to break a single law. The core of the majority's reasoning is that Hawaii's approach inverted a right into a privilege that had to be granted, and that flipping a constitutional right into something contingent on someone else's permission is not consistent with how the right to carry has historically worked. The action step here, if you carry in a state that had a similar law, is straightforward. The presumption has flipped back. You do not need to hunt for a welcoming sign anymore before entering an ordinary business. But do not walk away thinking this ruling erased every restriction on where you can carry, because it did not. And getting this wrong is exactly how someone ends up in a situation the ruling never actually protected them in. 3 things remained fully in place. First, so-called sensitive places, schools, government buildings, courthouses, polling places, remain places where states can restrict or ban firearms entirely, and the Supreme Court has already upheld that category of restriction in earlier cases. This ruling did not touch that. Second, private property that is not open to the public, someone's actual home, is completely untouched by this decision. Nobody has the right to bring a gun into your house without your permission, and that was never in dispute. Third, and this is the part people misunderstand most often, individual business owners still have full authority to ban guns on their own property. They can still post a sign saying firearms are not welcome. They can still tell a customer verbally that carry is not permitted there, and if a customer ignores that after being told, they are still trespassing. What changed is only the default. Before, silence from a business owner meant carry was presumed banned. Now, silence means carry is presumed allowed, unless the owner actually says otherwise. The action step is to still pay attention to posted signage everywhere you go, because a shop that wants you unarmed can still tell you so, and now they have to be the one to say it instead of you needing to prove they said yes. This ruling reaches further than Hawaii alone. According to court reporting on the case, 4 other states, California, Maryland, New York, and New Jersey, have adopted similar default rule laws restricting carry on private property open to the public since Bruin came down in 2022. Federal appeals courts covering those states, specifically the 2nd, 3rd, 4th, and 9th circuits, had already been ruling against versions of this scheme state by state in the years leading up to Wolford, with Maryland's case in particular sitting at the Supreme Court's doorstep waiting on this exact decision. Wolford does not automatically strike every one of those states' laws down by itself, since the ruling technically resolves Hawaii's specific law, but it sets the controlling legal standard that lower courts in those other states are now bound to apply, which is why legal observers describe this decision as effectively closing the door on the entire default rule strategy nationwide, not just in Hawaii. The action step, if you live in or travel through California, Maryland, New York, or New Jersey, is to watch your own state's response over the coming weeks, because these laws are now functionally dead, but the formal process of striking each one down, state by state, is still working its way through the courts. The ruling was not without serious disagreement, and understanding the dissent matters, because it tells you where the next fight is likely to happen. Justice Ketanji Brown Jackson dissented, joined by Justice Sonia Sotomayor, arguing that this case was never really about gun rights at all, but about a basic principle of property law, the right of an owner to control who enters their land and under what conditions, and that requiring a gun owner to get permission before entering someone else's business does no violence to the Second Amendment any more than requiring permission to enter someone's home would. Justice Elena Kagan filed a separate dissent as well. The 3 dissenting justices see this ruling as the majority prioritizing a gun owner's convenience over a property owner's traditional right to set the terms of who comes onto their land armed. That disagreement, property rights versus gun rights, is not resolved by this decision. It is simply decided in gun rights' favor for now, by a 6-3 margin, and it is very likely to resurface in the next case testing similar ground. The reaction from both sides tells you something useful about what actually changed. Gun rights organizations treated the ruling as a major, clean win, one of the more decisive Second Amendment victories of the post-Bruin era. On the other side, groups including Everytown for Gun Safety and its affiliated volunteer networks, Moms Demand Action and Students Demand Action, responded not by claiming the ruling was reversible, but by shifting focus toward encouraging individual businesses to voluntarily post signage restricting firearms on their own premises, which is precisely the tool the ruling left fully intact. That response itself confirms the actual scope of the decision. Nobody serious on either side is claiming business owners lost the ability to keep guns off their property. The fight simply moved from state law to individual signage, one business at a time. Now let's talk about the ruling that came first 8 days earlier, because it is arguably the more surprising of the two, precisely because of how lopsided the vote was. On June 18, 2026, the Supreme Court decided United States versus Hemani. And this one was unanimous, 9-0, with every single justice agreeing on the outcome, even though several wrote separately to explain different reasoning. The case involved a man named Ali Hemani, a dual citizen of the United States and Pakistan, born in Texas, who had spent most of his life living with his parents in the Dallas area and working a stable job. In 2022, federal agents searched his family's home while investigating suspected terrorism-related activity, a suspicion that, based on the public record of this case, did not result in any terrorism charges. During that search, Hemani cooperated fully. He surrendered a gun he kept in the house, pointed agents toward marijuana on the property, and told them in an interview that he used marijuana about every other day. More than 6 months later, the government charged him, not with anything related to the original investigation, but under a federal law, 18 U.S.C. Section 922 G3, which makes it a felony, punishable by up to 15 years in prison and lifetime disarmament for an unlawful user of a controlled substance to possess a firearm. A federal district judge dismissed the charge, the Fifth Circuit Court of Appeals affirmed that dismissal, and the government took the case to the Supreme Court, which agreed to hear it. Justice Neil Gorsuch wrote the opinion for a unanimous court. The core of the government's argument was that Hemani's admitted regular marijuana use was by itself enough to permanently strip him of his Second Amendment rights, regardless of how much he used, what effect it had on him, or whether he posed any actual danger to anyone. Gorsuch rejected that theory specifically, not the underlying law in every application, but this particular argument that mere regular use, without any individualized evidence of danger, automatically disqualifies someone. He pointed out that the government's own logic would extend just as easily to someone who regularly takes a spouse's prescription sleep medication or a college student who routinely borrows a friend's prescribed stimulant to study, situations nobody would treat as inherently dangerous. He also noted that the government's own conduct undercuts its position, since marijuana was reclassified during the litigation of this very case from the most restrictive federal drug category to a less restrictive one, and federal prosecutors have been directed since 2013 to generally deprioritize enforcement against marijuana users in states where it is legal, a group that now includes roughly 40 states in some form. Worth knowing for context, prosecutions under this specific provision, the unlawful user ban, make up only a small fraction of federal gun possession cases overall. Government data cited in the litigation put it at roughly 5% of all prosecutions under the broader federal statute banning gun possession by prohibited categories of people, which includes convicted felons and several other groups entirely untouched by this ruling. It is critical to understand exactly how narrow this ruling actually is, because overstating it is the single most common mistake people are already making online. Gorsuch was explicit that the decision does not address whether the government can prosecute someone who is an addict, someone who is presently intoxicated while carrying a firearm, someone using a more dangerous controlled substance, or the completely separate law banning firearm possession by convicted felons. The ruling applies specifically to a prosecution built on nothing more than an admission of regular use, with no other evidence of danger or impairment at the time. If a state or federal prosecutor can point to actual impairment, addiction, or a more dangerous substance, Hemani does not automatically protect a defendant in that situation. Justice Jackson, joined by Justice Sotomayor, wrote separately, agreeing with the outcome, but using the opportunity to argue more broadly that the historical tradition test the court has used since Bruin produces inconsistent, unpredictable results across different courts, and that a return to a more flexible balancing approach would serve constitutional rights better. That critique did not change the outcome of this case, but it signals at least two justices are looking for an opportunity to revisit how these cases get decided at a more fundamental level. Put both rulings side by side, and here is the actual factual picture of where things stand as of this recording. If you are a legally licensed carrier in a state that had a default consent rule for private property, That presumption has flipped in your favor, though sensitive places and property owners' explicit refusals still apply exactly as before. If you are a regular marijuana user in a state where it is legal and you otherwise lawfully possess a firearm, the federal government cannot automatically strip you of that right using your admitted use alone as the sole piece of evidence, though this protection does not extend to addiction, impairment while armed, or more dangerous substances. Neither ruling touches background checks, neither ruling touches the ban on firearm possession by convicted felons, and neither ruling means every gun restriction anywhere has disappeared. Anyone telling you otherwise in either direction, either that nothing changed or that everything just became legal, is not describing what these two opinions actually say. Let me clear up 3 specific claims I have already seen circulating since these rulings came down, because each one takes a real decision and stretches it into something the court never said. The first claim is that Wolford means you can now carry into any building at all, including schools, courthouses, and government offices. That is false. Sensitive place restrictions were not before the court in this case and remain fully enforceable exactly as they were before June 25th. The second claim is that Hemani means marijuana use is now irrelevant to gun ownership entirely, that any drug user can own a firearm without consequence. That is also false. The ruling is explicitly limited to prosecutions based on regular use alone, with no other evidence, and specifically preserves the government's ability to prosecute cases involving addiction, present intoxication while armed, or more dangerous substances. The third claim, and this one is more of a timing error than an outright falsehood, is that every state with a default consent law is now immediately unenforceable everywhere. Wolford directly struck down Hawaii's version. California, Maryland, New York, and New Jersey's similar laws are now standing on the same legally condemned ground, but the formal process of a court striking down each state's specific statute still has to run its course in each jurisdiction, even though the outcome is effectively settled. So here is what I would actually do with this information if I were you. If you carry, do not assume every business you enter is automatically open to you now. Still watch for posted signage because owners retain full authority to say no. They simply have to say it now instead of you needing to find where they said yes. If you live in California, Maryland, New York, or New Jersey, and your state had a similar default rule, watch your own state's official channels over the coming weeks for how officials respond, because the legal standard has shifted even before every state's specific law has been formally struck down in court. If you are a marijuana user who also owns a firearm, understand that Hemani protects you from a very specific kind of prosecution, one based solely on an admission of regular use with nothing else, and it does not give you blanket protection if there is evidence of impairment, addiction, or a more dangerous substance involved. And regardless of any of this, sensitive places, schools, government buildings, courthouses, polling places remain fully off limits under both federal and state law, untouched by either decision. Here is what happens next procedurally, because neither of these cases is fully finished. In Wolford, the Supreme Court reversed the lower court ruling and sent the case back down, which means Hawaii's courts and legislature now have to actually implement the new legal standard rather than the Supreme Court rewriting the state's statute book directly. Expect Hawaii's legislature to attempt some narrower replacement, possibly focused specifically on posted signage requirements or specific categories of sensitive commercial locations that might still survive scrutiny, though any new attempt will be measured against the exact reasoning the majority just laid out. In Hemani, because the ruling was framed narrowly around this specific set of facts, expect federal prosecutors to shift toward building cases with more individualized evidence of impairment or danger going forward rather than relying on an admission of regular use alone, and expect continued litigation testing exactly where that line sits, since the court explicitly left addiction, present intoxication, and more dangerous substances open for a future case to resolve. Neither ruling is the final word. Both are the current word, which is the more useful thing to actually know today. Step back and look at what actually happened here across these 8 days in June. These are not two random, disconnected wins stacked together for a headline. They are both direct descendants of the same 2022 Bruin decision, working out two very different applications of the same historical tradition test the court adopted back then. One dealing with where a right can be exercised, the other dealing with who can be stripped of it and on what evidence. The unanimous Hemani decision shows there is a floor of agreement even among ideologically opposed justices about how far a disqualification law can reach without individualized proof of danger, a floor solid enough that liberal and conservative justices alike were unwilling to let the government strip a right based on an admission alone. The far more divided Wolford decision shows that when a right bumps up against another party's property interest, the court's newer conservative majority is willing to draw that line firmly in the gun owner's favor, over sharp, serious objections from three of their colleagues who see the same facts through a property law lens instead of a gun rights lens. Both rulings trace back to the same 2022 framework, applied by the same 9 justices, and yet they landed on opposite ends of the agreement spectrum, which tells you the historical tradition test itself does not produce predictable unanimity just because it produces an answer. If this helped you actually understand what changed instead of guessing from headlines, hit like so it reaches other people trying to separate the real rulings from the exaggerated versions circulating right now, and subscribe if you have not, because state legislatures are about to respond to both of these decisions, and I will be covering that the moment it happens, not weeks later. This is not the kind of story that resolves itself in one video. Hawaii will attempt some kind of legislative response. The remaining states with similar private property laws will see their own cases move through the courts over the coming months, and federal prosecutors will start testing exactly how far Hemani's narrow protection actually extends the next time a similar case comes across a U.S. attorney's desk. Tell me in the comments which of these two rulings actually affects your day-to-day situation more, the private property question or the marijuana question, because that tells me exactly what to dig into next, and whether the follow-up video should be about Hawaii's legislative response or about how prosecutors are adjusting their approach after Hemani. Either way, the actual opinions are public record, running dozens of pages each, and worth reading yourself if you want more than any single video, mine included, can responsibly compress into 20 minutes.